And finally, we'll turn to Professor Farrah Raza, who is a stipendiary lecturer in public law at Pembroke College, University of Oxford. Professor Raza, I'll turn it over to you.
Thank you very much. Hello, everyone. Thank you to the organisers, as well as the other panelists and the audience. I look forward to engaging with you. I have a presentation that I'm going to share just as a visual aid. Please let me know if it doesn't show up, but I'm hoping that it works. Is that all right?
That works.
Okay, great. Okay, thank you. So my presentation is on religious exemptions and the law. Since I'm approaching this from a European and comparative perspective, I'm going to keep the discussion more broad and general so that we can hopefully engage in a sort of general discussion about the points that have been raised in the other presentation. So my presentation discusses the Religious Freedom Restoration Act by focusing on the question of religious exemptions. My recently published book entitled Religious Accommodation and Its Limits addresses the complex question of limitations to the right to freedom of religion or belief. In chapter 2 of my book, I engage with the question of the legitimacy of religious exemptions. In this presentation, I provide an overview of the arguments for and against religious exemptions. And ultimately, I argue that the workability of exemptions is more appropriately understood within a general framework of religious accommodation. So, what are exemptions? Exemptions are a specific legal technique that allows individuals or groups to not comply with a specific law or rule that applies to everyone else. So exemptions can be codified in statute or granted on a case-by-case basis. And accordingly, religious exemptions from generally applicable laws are a hotly contested issue across jurisdictions. So what is the exemptions debate? Here I just want to set out or sketch out the two broad schools of thought. On the one hand, religious exemptions are necessary to realizing the right to freedom of religion or belief in practice for many religious believers and minorities. On the other hand, other people argue that religious exemptions are considered to result in unequal and unfair treatment between those who benefit from exemptions and those who do not. So is religion special? Much of the exemptions debate has been premised on the underlying assumption that it is necessary to establish that religion is special in order to justify its accommodation. And as you can imagine, that's caused a lot of debate and controversy. And more specifically, is it justified to set apart religion as a distinct category for protection in law? Now, one of the other members of the panel went over the complex question of defining religion, especially in a pluralistic age where many people identify as religion but do not necessarily follow a specific organized institution or religion. So should religious exemptions be extended to include other categories of secular and comparable beliefs? I'm just going to set out here a number of examples of exemptions. So the first one, which has been litigated in the European context, religious slaughter of animals, which is unlawful in most European jurisdictions. And therefore, those members of the Jewish and Muslim communities often benefit from an exemption in order to carry out the slaughter of animals in accordance with their religious beliefs. But this has been controversial and, as I mentioned, litigated in various European countries. The second example is religious male circumcision, again, usually affecting those who identify as Jewish or Muslim. And again, in many jurisdictions in Europe, this is a controversial example that requires a specific exemption. A third example is exemptions from wearing safety helmets, which typically affects Sikh men who wish to wear the turban, and English law, for example, accommodates this. The fourth and fifth examples, abortion and related procedures and military service, also concern, we might say, non-religious exemptions, or where, for example, pacifists might have concerns about military service, and this was discussed in the previous panel, for example. And the fourth and the fifth categories also include a range of secular and ethical beliefs, which lead people to request an exemption from participating in, for example, abortion. And again, as you will know, these have also been litigated in the famous case of the US case, Hobby Lobby. So we can see that religious exemptions have been extended in various jurisdictions to include a range of non-religious beliefs, loosely defined, or similar ethical concerns or beliefs that might potentially also fall under the remit of the law. Excuse me. So just to go through some of the key arguments against religious exemptions and why they're deemed to be controversial. In my book and my essay, I grouped the various issues into sort of three broad categories of arguments. The first is the preference choice argument. And essentially, this argument is based on the statement that religion is essentially a choice, a preference, and religious believers put themselves in a position where their religious beliefs conflicts with the law. And the argument is that religious believers, the burden is on them to resolve that conflict, and the state or employers should not be burdened with trying to resolve that conflict. These arguments about choice, for example, was explored in the case of Shabina Begum, which concerned religious dress in the UK at a school. And some of the arguments there were concerning choice was that the student could choose to go to another school, for example, that did accommodate her religious dress. The second set of arguments I group under the heading of the intensity cost argument, which is to say that although many religious believers will argue that their religious belief is intensely and sincerely held, and also has consequences, negative consequences, for example, if they breach their religious belief or duty, the counter argument is that, well, many other beliefs are intensely held and also have costs. So what is it about religious beliefs that deserve special protection or protection in law? And thirdly, the final set of arguments, excuse me, relate to the rule of law. And the argument is as follows, that religious exemptions undermine equality and result in unfair treatment, and ultimately undermine the rule of law because it allows certain groups or individuals to benefit from an exemption and not to obey the law in a specific context. So those are the various arguments in a sort of summary nutshell against religious exemptions. But of course, the importance of the exemptions has been captured across jurisdictions in the case law. The central importance of one's conscience was recognised by Lady Hale in the case of Dugan, which concerned in the healthcare context Roman Catholic nurses who wished to not participate in procedures relating to abortion. And Lady Hale emphasised that the exercise of conscience is an internal matter which each person must work out for herself. It's bound to be subjective. So really emphasising that for many individuals, this question of conscience and exemptions is not only just a personal matter, it relates to important life decisions that people have to decide about in different contexts. And so there's a recognition in the case law of the importance of conscience. Now, Of course, the question that follows is what should the law do about that and particular question of granting religious exemptions. So of course we have to take a contextual approach. It does depend on the context and the specific issue that is being litigated. But I argue that religious exemptions are only one form of religious accommodation. Religious beliefs, as well as secular or sincerely held beliefs, are worthy of legal protection. And of course, that's quite a complex issue, as has been discussed in the previous presentation, with the definition of religion, increasing pluralism, and more people identifying as non-religious or holding comparable ethical beliefs, which they would argue should also be accommodated in law. I would favour at the first instance a broad approach or a wide and generous approach to this particular problem. However, I would also argue that a nuanced account of the rule of law based on substantive equality is able to accommodate a range of exemptions without necessarily compromising the integrity of the legal system. So we can take a generous approach at the first instance to exemptions, but I offer a solution by proposing a specific model of religious accommodation as set out in my book as a way of balancing the competing interests and ensuring that religious exemptions, for example, do not breach the rule of law or become unworkable. So that's a very quick summary of the sort of key issues in that broader debate of the exemptions debate. Is religion special in the context of increasing pluralism? And I briefly just set out the arguments against religious exemptions and some exemptions, both religious and non-religious conscience claims that have been litigated and accommodated in various jurisdictions. So that's a very quick summary. Thank you very much.